Hello. 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 Hello.
Hello, hello.
Hello.
delay வருமியா?
Hello. 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 Hello.
இப்ப கட் ஆயிடுச்சா?
Hello. Hello. Hello, hello, hello. Welcome to Annual National Moot Court Competition. Hello, 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 hello. Mic check. Mic check. Hello, mic check. Hello, mic check. Hello, mic check. Hello, 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 hello. Welcome to the SRM Moot Court Final Competition. Hello, mic check. Hello, hello, mic check.
Hello. Mic check. Mic check.
Okay, you can hear. Fine.
Hello, Anand. So thank you so much for the services rendered to SRM Institute of Science and Technology. Huh? Okay. Hi. Hello. Good morning. Nina. Okay. Good enough. This is too close, no? No? Is this good enough? Should I keep talking? I can. Continue what? Welcome to California. Ah, thanks. What is wrong? We could have. Yes. Thank you. I'm not on the field. Yes. Annual moot court competition of SRM School of Law. One, two. क्या हुआ? You. Should I continue talking? Okay, sir. And oh, so they're checking the live. Oh, we are like they're checking the live.
participants and spectators. Welcome to the final round of the SRM 9 moot court competition. We are thrilled to have reached this stage of this competition where the stakes are higher and the legal acumen of our participant is truly to the test. Before we proceed, the court master seeks the permission of the honorable judges to deliberate upon the court rules for the final rounds. Much obliged, your lordship. A final round lasts for 90 minutes. A team shall be provided 45 minutes to make submission on behalf of the sides which they are representing. The 45 minutes shall be rebuttal or sur-rebuttal. A speaker shall be entitled to make submission for not more than 25 minutes. Team shall be at their liberty to bifurcate time of their oral arguments subjected to the maximum time limit of 40 minutes. The team shall be communicated to the court officer their time verification before the commencement of the rounds. Please note that if any team have failed of allowed time of rebuttal or sur-rebuttal, it would be presumed as an act of failure of their rights to rebuttal or sur-rebuttal, and the team shall not at a later stage can claim their right to rebuttal or sur-rebuttal. No team by default shall be entitled to an extension of time beyond the prescribed time limit of 45 minutes. However, the time extension can be granted by the honorable discredited judges. Notification of remaining time will be given to the team at the following intervals of 10 minutes, 5 minutes, 2 minutes and 0 minutes, that is time up. Team shall submit their compendium or any such material to the court officer before the commencement of the oral rounds. Team shall during the course of arguments pass or share any materials to the judges only after taking due permission from the honorable judges. Obtaining permission. The material shall be passed on the bench only through the court officer. The researcher of the team is allowed to pass maximum chits of 5 during the course of their oral arguments. Teams are strictly prohibited from asking any comments, reviews from their performance from their honorable judges. Usage of any form of electronic gadgets are strictly prohibited. Any team found using any form of electronic gadgets will be disqualified from taking part in the subsequent rounds of the competition. Thank you.
Council seeks permission to provide the compendium on behalf of the appellant. Greetings to the bench. Council seeks permission to address the bench collectively as Lordship and specifically as Lordship. Much obliged, your Lordships. I am the Speaker 1 and I will be dealing with issue 1 and 2, and my co-counsel will be dealing with issue 3 and 4, and she is our researcher and we are representing the appellant, Miss Lydia. With your Lordship's permission, the Council would like to state the facts which was in favor of the appellants. Much obliged, your Lordships. The MS Creative AI Limited is the respondent in this present case, which created an artificial intelligent humanoid called Raha. That particular Raha in turn generated number of artworks, your Lordship. The one of the problem which come into the play in regard to this particular case is the machine learning process. Through that machine learning process only they generate the art, your Lordship. But in the machine learning process, they fed number of inputs, data and patterns from various copyrighted works of the authors and artists without their permission, your Lordship. And that particular data, patterns and the inputs were used by the AI Raha to come up with the future prediction. And that future predictions were called as the generated artwork, your Lordship. Subsequently, due to this process, particular artworks were regarded as a mere modification of the existing copyrighted work, your Lordship. So in the meantime, in January 2023, the MS Creative AI Limited exhibited an artwork called Beauty Queen in the DigiArt Art Gallery, your Lordship. In that Beauty Queen art, the AI Raha created the artwork of Lydia, who is a famous actress in Indigo. That particular art is also a generated art, your Lordship. That particular art is called as the Beauty Queen. But what amounts to the problem here is, the particular Lydia was depicted in an obscene manner, your Lordship. because the particular Raha AI created the women in a women adorned in a resplendent milet. A milet is a kind of dress which is a swimsuit kind of dress, your lordship. Without her permission itself, it was exhibited in the art gallery itself, your lordship. So being aggrieved, the Lydia has filed a copyright infringement case before the trial court, and the trial court made two essential observations, your lordship. Firstly, the trial court have stated that the generated artwork share resemblance with pieces by multiple traditional artists. And secondly, the court observed that the digital art by Araha resembles the Lydia's face, your lordship. So they have concluded that it was actually the Lydia's picture which was portrayed in the beauty queen art, your lordship. So being aggrieved by that order, the appellant Lydia came before the Honorable High Court of Warren under Section 13(1)(a) of the Commercial Codes Act 2015, your lordship. Since the matter is posted for argument today, hence the matter is present, your lordship. If your lordship is satisfied with the facts, can the council proceed with the issues, your lordship? Much obliged. Moving with the issue 1. Whether the copyright law of Indigo recognizes artificial intelligence like Raha as the author is the first issue, your lordship. Your lordship, it cannot be, that is the artificial intelligence like Raha cannot be regarded as an author based on following three contention, your lordship. Firstly, it lacks personality. And secondly, there is a special right called author's special right, which was conferred in section 57 of the Copyright Act, your lordship, which is a moral right only in relation to the natural person. So that particular right cannot be enforced by the AI Raha, your lordship. And in order to substantiate these two contention, the council is relying on the judgment, that is the Stephen Thaler versus Shira Perelmutter case, your lordship. Moving with my first contention, that is the AI Raha lacks personality, your lordship. In order to confer authorship, section 2D6 comes into play, your lordship. Section 2D6 of the Copyright Act states that author means in relation to literal, dramatic, musical or artistic work which is computer generated, the person who causes the work to be created has to be the author, your lordship. But as per the law of Indigo, the particular AI was nowhere recognized artificial person. At the same time, it was not recognized as a natural person, your lordship. So it lacks the personality itself, your lordship. In the absence of personality, it cannot be regarded as the author, your lordship. This was my first contention, your lordship. Secondly, indeed, your lordship. Indeed, your lordship. But in addition to the personality status, here there is an extra additional requirement, that is the particular art has to be generated by the Raha itself, your lordship. But the council couldn't hear, your lordship. The term person includes legal person as well as the natural person, your lordship. So legal person means a person recognized, the artificial person recognized by law can be regarded as a legal person, your lordship. But in addition to the personality status, if the authorship was granted, the particular Raha cannot enforce the moral right itself, your lordship. So that's the reason we state that the personality status cannot be given, your lordship, in relation to the facts of this case, your lordship. Much obliged, your lordships. Moving with my second contention, that the Raha shall not exercise the author's moral right which was conferred under section 57 of the Copyright Act. Section 57 of the Copyright Act relates to right to integrity, your lordship. That particular right to integrity is regarded as a moral right, your lordship. So the moral right can be accessed by the natural person because the particular author's special right which was enshrined under section 57 is only provided to the author and not to the owner, your lordship. Why it was provided only to the author is because author's special right to restrain or claim damage on distortion, mutilation, modification of his work which is prejudicial to his the artificial intelligence is not affected by that particular act, your lordship. So it nowhere affects the dishonor and it nowhere amounts to reputation, your lordship. So the particular special right itself cannot be accessed by the raga. But as per the Copyright Act, the author's special right is one of the essential part, your lordship. If an essential special right itself cannot be enforced by the raga, why it is essential to be recognized as an author is the humble contention of the appellant, your lordship. In order to substantiate this particular point, the council is relying on the Amarnath Sehgal versus Union of India case, your lordship, for which the council invites the court attention towards the compendium leaf H, in which it has been stated that moral right is the soul of author's work, your lordship. So, when the moral right itself cannot be accessed by the artificial intelligence, it cannot be regarded as the author, your lordship. That is our humble contention, your lordship. In order to substantiate these above two contention, the council is relying on the judgment of Stephen Thaler versus Shira Perelmutter case, your lordship. In that particular case, the creativity mission is an AI, your lordship. That particular AI created an art called an entrance to the paradise, your lordship. So that particular case came to the court, and the court have declared that the art which was generated by the human only can be regarded as an author, your lordship. So, in reliance with this particular judgment, the authorship shall not be granted to the Raha, your lordship. That concludes my submission for the issue 1, your lordship. If your lordship is satisfied with the issue 1, can the council proceed with the issue 2, your lordship? Much obliged, your lordships.
Council, I have a question.
Indeed, your lordship.
Can you explain us how the AI functions?
Indeed, your lordship. Your lordship, there is a process called a machine learning algorithm. In the machine learning algorithm, a number of inputs of the various copyrighted works were fed into the artificial intelligence, your lordship. That particular data were taken without the permission of the artist or author, your lordship. And that particular inputs were used by the Raha to come up with a prediction, and that future predictions were only called as the generated artwork. So there exists a number of resemblance and imitation of the copyrighted works, your lordship, which was fed, your lordship. This is how the Raha works, your lordship.
Number of resemblances.
In addition to the resemblance, there exists a criticism that there is only a mere modification of the existing work, your lordship. In this particular case also, your lordship, Lydia's face is copied, your lordship. The respondent cannot contend that that is not a substantial part, your lordship, because Lydia is a famous woman and she is also a famous actress in the Republic of Indigo. If the respondent, while the generated art is creating a face of Lydia itself, they will know that it is the face of Lydia. So at the time itself, they could have stopped and asked her permission, and they could have asked whether to exhibit it or not. But they have the illegal motive to use the publicity of the particular Lydia, and the personality right of the Lydia is also violated because of this particular respondent's act, your lordship, because the particular respondent have used her in an obscene manner to grab their commercial benefits, your lordship, which amounts to violation of privacy and violation of the personality right also, your lordship.
How answering this issue will help your case? How will you advance your case?
Your lordship, the particular Lydia has came before the Honorable High Court of Warren only because of the infringement of copyright, but in addition to that, she allegated that there exists a depiction of her amounts to obscenity and right of privacy, your lordship. So these are the allegations made by the appellant, your lordship. So it is.
Our question to you is how answering this question will advance your case?
Your lordship, that fulfills the mens rea of the respondent, your lordship. So they fail to take any liability.
Raha can't be recognized as author of this work.
Indeed, your lordship.
Then how it's going to help you?
Indeed, your lordship. Since the issue 1 was all about whether it can be recognized, your lordship. So our contention is it cannot be regarded as a person. So it is essential for the appellant to deal with that issue itself, your lordship. That's the reason the particular issue was dealt by me, your lordship. I beg your pardon, your lordship. Could you please restate the question, your lordship?
You are appealing for media.
Indeed, your lordship. Indeed, your lordship.
The answer to this question
Indeed, your
you
lordship.
want us to answer should advance your case.
Indeed, Your Lordship. Your Lordship, the question, that is the issue 1 was created only for the moot proposition, Your Lordship. That particular authorship related matter was not related to the Lydia's case, Your Lordship. So it is essential for us to submit this.
Your addressing is more academically,
Indeed, Your Lordship.
not with reference to your case.
The issue 1 is nowhere related to our particular Lydia's case, Your Lordship. Much obliged, Your Lordships.
Counsel, I have one more question.
Indeed, Your Lordship.
You have said that Lydia approached the court for infringement of copyright
Indeed,
on the
Your Lordship.
basis of similarity with her personality, or is it on the ground of obscenity?
Your Lordship, she came before the before the trial court.
No. Before answering that, please keep in
Indeed, Your
mind that
Lordship.
your case is for infringement of copyright.
Indeed, Your
Is
Lordship.
it based on similarity or is it based on obscenity?
It is based on the imitation of her face, Your Lordship. For the obscenity related matters, we have already filed before the criminal court, Your Lordship. The particular case is still pending, Your Lordship. In addition to the infringement, the allegations are also regarding the obscenity. That is the only reason we are stating that particular point, Your Lordship. But the particular case is filed only because of the infringement, Your Lordship. Much obliged, Your Lordships. Indeed, Your Lordship. Indeed, Your Lordship. It is the imitation of her face, Your Lordship. Indeed, Your Lordship.
Please clarify us whether it is copied, whether it is resemblance or imitation.
The court observed it as resemblance, Your Lordship, but
Observation of the court, right?
indeed, Your Lordship, the court have observed that there exists a resemblance. But being agreed by that order only, the Lydia have came before the Honorable High Court. Our humble contention is that, Your Lordship, her face was used as a substantial part for that particular beauty queen art, Your Lordship. Because of her face only, the particular beauty queen art gained the commercial value, Your Lordship. So whenever a substantial part is copied, that amounts to violation of piracy and copyright infringement, Your Lordship.
Do you have any case or judgment
Indeed, Your Lordship.
similar?
Indeed, Your Lordship. In the Anil Kapoor versus... Indeed, Your Lordship. Your Lordship, the council doesn't have any exact case in relation to resemblance, but the council could hopefully satisfy the judge, the Honorable Lordships, based on this particular point, Your Lordship. Because in the K.R. Venugopal Sharma versus Sanghu Ganeshan, this particular case was observed in the Hulm Industries case, which was dealt on the 17th October 2023, where they have stated that an infringement is complete, even the reproduction was not exact, Your Lordship. So a resemblance or reproduction, a general reproduction will obviously come into a conclusion of infringement of piracy, Your Lordship.
But the resemblance has been defined anywhere in any judgment?
In the Copyright Act, it was not defined, Your Lordship. The council is not aware whether it was defined in any particular judgments, Your Lordship.
Counsel, your case is infringement of copyright.
Indeed, Your Lordship.
What is your copyright?
Your Lordship, a copyright for a particular artistic work comes when it is created itself, Your Lordship.
Forget the theory. In
Indeed,
this
Your
case,
Lordship.
what is your copyright? Is your copyright your face, or is it something tangible?
Indeed, Your
What
Lordship.
what does your statement of fact say about that?
Indeed, Your Lordship. Your Lordship, as per the fact of this case, her photograph which was uploaded in the Facebook is the copyrighted work of the Lydia, Your Lordship.
Okay, so your copyright that
Indeed,
you
Your
claim infringement of
Indeed, Your Lordship.
is your photograph.
Indeed, Your Lordship.
Okay. Now, is that enough to pass the personality test?
Indeed,
You've
Your
been
Lordship.
arguing on the personality test. Is your photograph enough to pass off on the personality test?
Indeed, Your Lordship. Your Lordship, in addition to the photocopying, the personality right is also violated. So that is the only reason counsel stated that particular point, Your Lordship. As per appellant's allegation, her particular photo is copied. So that's the reason she came before the trial court. But the court observed only her face, Your Lordship. So being agreed by that order only, the counsel came before the appellant came before the Honorable High Court, Your Lordship.
On a practical note, forget this case. On a practical note, you're an actress of great repute. You upload your photograph on Facebook. Do you
Indeed, Your
want other
Lordship.
people to see it or not?
Indeed, Your Lordship.
Do you want other people to transmit it or not?
Indeed, Your Lordship.
Correct. Then what is the
The
issue about?
council would like to humbly differ from this point, Your Lordship. So, because she is being an actress, without her authorization, it was depicted in an obscene manner. So, the term no will never become yes, Your Lordship, only because she is becoming an actress, Your Lordship. So, the respondent cannot take the personality right of the Lydia or her privacy as taken for granted, Your Lordship. That is our humble submission, Your Lordship.
Okay, go on.
Much obliged, Your Lordship. Council couldn't hear, Your Lordship. Indeed, Your Lordship.
That is why you are agreeing.
Indeed, Your Lordship.
No obscenity. Will you able to accept it? Will you accept it?
In the absence of obscenity, also there is a violation of copyright, Your Lordship. For that, the opponent will move to the trial court, Your Lordship. Much obliged, Your Lordship. Your Lordship, the particular woman was depicted in a swimsuit, Your Lordship, without her permission, Your Lordship. Your Lordship, it was done without her permission, Your Lordship. Since the photograph of the particular Lydia and also the photograph of the particular beauty queen art was not provided in the moot proposition, Your Lordship. But the court observed that there existed. Indeed, Your Lordship. Indeed, Your Lordship. The court have observed that there is a legal queries in relation to the obscenity, Your Lordship. So, in the absence of obscenity, the particular observation regarding the legal complexity itself will not arise, Your Lordship. Due to the existence of the obscenity only, the legal queries itself arise, Your Lordship.
How do you define obscenity?
Your Lordship, obscenity and the art, when it is mixed, the art has to overweight the obscenity, Your Lordship. In this present case, as per the facts of this case, there is amounting to the obscenity and in the depicting of her, the Lydia, Your Lordship.
I'm clarifying my question.
Indeed, Your Lordship.
How do you define obscenity?
Your Lordship, indeed, Your Lordship, in the fact they have stated she was adorned in a miler, that is a swimsuit kind of.
I'm not getting into the facts.
Indeed, Your Lordship.
I'm asking you, how is obscenity defined or is it defined?
What amounts to obscenity actually? It may differ from case to case, person to person.
Anything, indeed, Your Lordship.
It is by its very name, it is art.
Anything intrude the lavishious thought of a prudent man, then it amounts to obscenity, Your Lordship.
Then the question will come, who is a prudent?
Every human being, any person, as per contract act,
So it will be easy for us.
indeed, Your Lordship.
You can quote jurisprudentially any judgment, any citation, any definition. It will support your argument. Do you have anything substantial?
Indeed, Your Lordship. Your Lordship, a prudent man is, the council don't have any substantiating regarding the judgment, Your Lordship, but logically, much obliged, Your Lordships. If Your Lordship is satisfied with the issue 1, can the council proceed with the issue 2, Your Lordship? Much obliged, Your Lordship. Whether the artistic work created by the Raha passes the test of originality is the issue 2, Your Lordship. Your Lordship, the test of originality is dealt in section 13(1)(a) of the Copyright Act. In the Copyright Act, it has been stated that copyright exists in original, literal, dramatic, musical and artistic work. But the term originality was nowhere defined in the Act, Your Lordship. But the test of originality is sine qua non for obtaining the copyright protection, Your Lordship. So it is essential to fulfill the test of originality, but in this present case, AI fails to fulfill the test of originality, Your Lordship. So in the absence of definition, indeed, Your Lordship. Indeed, Your Lordship. The Anil Kapoor versus Simply Life India is one of the leading case which was dealt on 28th September 2023, Your Lordship. In that particular case, this is the only case which dealt regarding AI imitation of a celebrity, Your Lordship. In that particular case, Anil Kapoor is a celebrity whose voice, face and personality was imitated by the respondent, that is the Simply Life India, through the AI tool, Your Lordship. They have imitated his voice, face and personality. So the court held it amounts to violation of privacy and it also amounts to violation of his personality right, Your Lordship. So the court have provided the injunction in favor of the Anil Kapoor, Your Lordship. Relying on this particular judgment, the appellant Lydia also can claim for the injunction, Your Lordship. Indeed, Your Lordship. In the Eastern Book Company versus D.B. Modak, Your Lordship, also in the University of London Press case, Your Lordship, in the both the cases, they have stated the definition of original, which means it should originate from the author and it should not be copied from the others, Your Lordship. This is the simple test, Your Lordship, which is the two essential tests. In this present case, the particular Raha copied the work, Your Lordship, because it substantially copied her face. That face was depicted in the artwork of the Lydia, Your Lordship. So when the substantial portion itself copied, it amounts to violation of piracy and it also violation of copyright infringement, Your Lordship.
Counsel,
Indeed, Your Lordship.
the findings of the trial court are not that it is copied or that it is an imitation. It
Indeed,
only
Your Lordship.
says the defendant or the respondent's digital art resembles Lydia's face.
Indeed, Your Lordship.
So would that amount to a direct copy?
Indeed, Your Lordship. Your Lordship, that is the reason the appellant have aggrieved, Your Lordship. That is the reason they came before the Honorable High Court of Varan, Your Lordship. Your Lordship, our humble submission is that even the resemblance also amounts to a violation of piracy, for which the counsel have quoted the K.R. Venugopal case, Your Lordship. A reproduction itself amounts to violation of her copyright, Your Lordship. In addition to that, the second test, which is the originate from the A itself, Your Lordship, but in this particular case, it was not originated from the A. We accept it, Your Lordship. Artificial intelligence is actually intelligent, but it is not intellect, Your Lordship. In order to be intellect, and the copyright protection only on the intellectual works, Your Lordship. So the thought or sentiment has to be expressed in a creative way to incur the copyright protection. But in this present case, the AI lacks the sentiment and the AI lacks the thought too, and it also lacks the creativity and it also lacks to express in a creative way, Your Lordship. At that time, it cannot be regarded as an intellectual work, Your Lordship. So in the absence of intellectual capacity, it cannot be regarded as it was actually originated from the AI itself, Your Lordship. Both the test was not fulfilled. As already stated, without the input, it cannot create output itself, Your Lordship. But if the same input was given by 10%, it amounts to same output for the 10 people also, Your Lordship. So it can be regarded that the test of originality is not passed, Your Lordship, by the AA Raha. If Your Lordship is satisfied with issue 1 and 2, the counsel will move on to the issue 3 and 4. It's a pleasure arguing before this bench. Much obliged, Your Lordship.
Much obliged, Your Lordships. The counsel is appearing on behalf of the appellant, Your Lordship. The counsel will be dealing with the issue 3 and 4, Your Lordships. Your Lordship, the issue number 3 is whether using copyrighted material to train an AI can be regarded as fair use or fair dealing, Your Lordship. Your Lordship, fair use or fair dealing means usage of a copyrighted material without the permission of an author up to some extent and with some restrictions and limitations, Your Lordship. Everyone has the right over the copyrighted material which is already published, Your Lordship, but that use must be with the purpose of education, research and for comment or criticism purpose, Your Lordship. Section 52 of Copyright Act 1957 has an exclusive provision for the exception of copyright infringement, Your Lordship. In that, Section 52(1)(a) have expressly stated that the copyrighted material can be used for the purpose of private or personal use and for education and research, Your Lordship. Here the Raha have used the copyrighted work of Lydia for the purpose of commercial purpose, Your Lordship. Her face is copied and made a digital artwork and that was exhibited in the Digi Art Gallery, Your Lordship, and this clearly shows the commercial purpose, Your Lordship. When an copyrighted material is used for the commercial purpose, it cannot be regarded as an exception for the copyright infringement under fair dealing, Your Lordship. And also, for For claiming the fair dealing, the copyrighted material which was used must have the 4-factor test, Your Lordship. The first factor is purpose and the character of the copyrighted work, Your Lordship. It must be transformative and it should not be of commercial nature, Your Lordship. As I've already stated, the copyrighted material, which is Lydia's photograph, have been used by the Raha and have created the digital artwork, and it was published in the DigiArt gallery, and it clearly shows the commercial purpose of the respondent, Your Lordship. And the second factor is nature of the copyrighted work, Your Lordship. The original copyrighted work and the copied work should not share the same nature, Your Lordship. The original copyrighted work's nature is the photograph, Your Lordship. And secondly, the Raha's work was the digital art painting, Your Lordship. They both share the same nature of showing the picturization, Your Lordship. And thirdly, the amount and substantiality of the portion used, Your Lordship. Here, in the first thing, Your Lordship, they share the same nature by having picturization, Your Lordship. For example, if the book is copied into a podcast or a movie, they have this different nature. But the photograph is copied and it was created as a digital art. Both have the same nature by having picturization. It was spectacular, Your Lordship. Much obliged, Your Lordship. And the factor 3 is amount and substantiality of the portion used, Your Lordship. Here, the substantial portion of the photograph was Lydia's face, Your Lordship. And in the Raha's digital work, the substantial part is the woman, Your Lordship. The woman was adorned in the resplendent My Lord. And the woman's face is the substantial portion, Your Lordship. The substantial part itself copied, Your Lordship. So it cannot come under fair dealing, Your Lordship. And lastly, the potential market value. The copyrighted work and the copied work should not reflect or create loss to the existing potential market value of the existing copyrighted work, Your Lordship. Raha have taken the Lydia's face and used it in an obscene manner, Your Lordship. As Lydia is a famous actress of Indiga, portraying her in such manner would definitely result in the loss of her potential market value, Your Lordship. I would like to conclude my issue by stating Getty Images vs. Stability Incorporation, which is a US case, Your Lordship, and which is more or less similar to our case also, Your Lordship. Getty Images is the photographic company which takes millions of photographs and posts in their websites, Your Lordship, which is published by the Getty Images with their own watermarks. Stability AI, who's the respondent, is the artificial intelligence generating company, Your Lordship. The purpose of the artificial intelligence of Stability AI was to recreate the photographs into the digital artworks, Your Lordship. The respondents have used more than 12 million photographs of Getty Images and transformed it into a generated artworks, Your Lordship. And that have been used for the commercial purpose, Your Lordship. The judgment was held in favor of the appellant, Your Lordship, because of the photograph have been copyrighted of the Getty Images and it has been used for the commercial purpose, Your Lordship. Relying on that, the judgment shall be held in favor of the appellant, Your Lordship. If the bench is satisfied with issue 3, the council would humbly seek permission to move on to issue 4, Your Lordship.
Council, not really. Please see issue number 3. Issue number 3 is not with usage of copyrighted material. Please see issue number 3. Using copyrighted material to train AI. How have you addressed that as being not fair or unfair dealing?
Indeed, Your Lordship. Using a copyrighted material without prior permission itself and copyright infringement, Your Lordship, first of all. And that material has been used for giving inputs to the artificial intelligence, Your Lordship. The artificial intelligence output would definitely reflect in the inputs given, Your Lordship. If 10 inputs have been given to the artificial intelligence, the output will generate from the inputs given, Your Lordship. If the copyrighted material itself given as an input, it will definitely resemble the copyrighted work. It definitely amounts to the plagiarism and copyright infringement, Your Lordship.
By the very nature of AI, is it really necessary to train artificial intelligence?
Indeed, Your Lordship. But in our case, Raha is specifically made for creating artistic digital works, Your Lordship. It cannot create on its own, Your Lordship. While giving comments and by giving the inputs, it can generate by using all the references taken by it, Your Lordship. It just uses a part from every copyrighted material and assembles and it gives as an output, Your Lordship. It will reflect in the copyright infringement of the inputs given, Your Lordship.
And the output includes bikinis as well.
Indeed, Your
Is
Lordship.
that what you're trying to say?
The council need much more clarification than the question.
Okay. Issue number 3 is only with reference to copyrighted material being used to train artificial intelligence, in this
Indeed, Your
case
Lordship.
Raha,
Indeed, Your Lordship.
and whether that is fair use or fair dealing.
It is not a fair use, Your Lordship.
Okay. And your argument so far has been there is copyrighted material in the form of photographs on Facebook of the appellant, uploaded by the appellant. Let's let that be a given. And that has been taken by AI, by Raha, and has it been adapted, modified, etc., or what is your case?
The whole face itself copied, Your Lordship. The
Just like
face is the
that.
substantial portion of Lydia, Your Lordship. When the output resembles the substantial part, it amounts to the copyright infringement, Your Lordship.
That's where the substantial thing comes in.
Indeed, Your Lordship.
Okay.
If the bench is satisfied. Indeed, Your Lordship. Indeed, Your Lordship. And it is also stated in that section itself, it should not be used for commercial purpose also, Your Lordship. If it is only used for the research purpose, it can be regarded as a fair dealing, Your Lordship. But it was used for the commercial purpose also, Your Lordship. It is stated in the 4-factor test, Your Lordship. In the case law of Chandrul, Chancellor of the University of Oxford versus Narendra Publishing House. For this, kindly refer footleaf number 3 of the compendium, Your Lordship. If the bench is satisfied, the council seek permission to move on to issue 4. Much obliged.
What about country being signatory to the TRIPS Agreement and Bern Convention? Does it give you the exclusive right or is it a limited right?
Your Lordship, as artificial intelligence are developing nowadays, so similar rights are given, Your Lordship, but that right would not infringe the existing rights, Your Lordship, and that right should not reflect in the violation of the fundamental right, Your Lordship. Here, the right of privacy of Lydia has been violated, Your Lordship, and whenever any act which is against the fundamental right and that would be punished, Your Lordship, and that should not be entertained, Your Lordship. Indeed, Your Lordship. Indeed, Your Lordship, the photograph which was posted by Lydia was not in obscene manner, but the artwork created was in obscene manner, which has the face of Lydia, Your Lordship. That is our humble contention, Your Lordship.
Question of obscenity is subject to, there is no precise definition. What it looks.
Indeed, Your
for
Lordship.
one, it may not be for others.
Indeed, Your Lordship.
Special reference to film actress.
Indeed, Your Lordship.
It can be interpreted in any way.
Indeed,
Because
Your
you have to
Lordship.
look into her, the whole career and all that, what she did and all. Because a mere statement of obscenity, it won't fit always. That is.
Indeed, Your
Suppose she is a
Lordship.
film actress.
Indeed, Your Lordship. She may be a film actress, but she is a woman, Your Lordship. A woman should not be portrayed in such
By
manner.
profession, she is a film actress.
The question is whether the privacy test is same for everybody.
Indeed, yes,
For
Your
a
Lordship.
conservative woman and again for a film actress. It applies same yardstick.
Indeed, yes, Your Lordship. Because it has been accessed without her permission. She has the right to wear whatever she wants, Your Lordship, but she itself contends that that picture is obscene in manner. So that should be questioned, Your Lordship.
We're coming back to the same thing.
Indeed, Your Lordship.
Access on Facebook is not a defense that's available to you, or is not an offense that's available to you, because you don't have privacy settings. You allow people to access. That's why I asked your co-speaker as well. I asked your co-speaker, is your case based on infringement of your photograph or on the basis of obscenity?
Indeed, Your Lordship, our case is purely based on copyright infringement, and we further alleges the copied work was in obscene manner, Your Lordship, which was invariable for the appellant, Your Lordship.
So you put it out on public domain and then expect people not to appreciate beautiful faces. Is that what you're trying to say?
Indeed not, Your Lordship. It can be used for a good purpose, Your Lordship, but portraying her in an obscene manner shall not be entertained, Your Lordship.
Intention behind this litigation is that to film actress, she wants to make it very popular by herself. The litigation purpose is has some other motive behind, ulterior motive.
Indeed not, Your Lordship. For
It's a common practice, and
In-
that's what we observe.
Indeed, Your Lordship, but she can gain fame by doing some other things. Why would she have to portray her in by contesting that she was in obscene, and with that bad fame, why should she do that, Your Lordship?
No, your client wants to remain in discussion. That is the very purpose is that one only.
Much obliged, Your Lordship. Your Lordship, the issue 4 is whether an A is capable of committing a criminal offence, Your Lordship. Your Lordship, it is humbly submitted on behalf of the appellant that an A is capable of committing a criminal offence, Your Lordship. In order to constitute crime, there is two essential ingredients, Your Lordship, that is actus reus and mens rea. Here, as we have already contended, A do not have the personhood and personality right. It does not have the mens rea also, Your Lordship. But with that, we cannot conclude that without mens rea, the A cannot commit a crime, Your Lordship. Mere actus reus is enough in the cases of A for committing a crime, Your Lordship. I would like to state it in two different perspectives, Your Lordship. In the first perspective, we will take our case itself. Raha and artificial intelligence have created a digital artwork which portrayed the woman in obscene manner. The Raha would have created it in an obscene manner, Your Lordship. The Raha do not have a mind to think whether the picture is obscene or not. It just have created. And in the second case, if the Raha goes in the hand of wrong user, for example, if I am the user and I am giving the command to Raha, to an AI to go and kill A, it will just receive my command and act accordingly. It will go and commit a murder, Your Lordship. In both the cases also, with mens rea and without mens rea, the A is capable of committing a criminal offence, Your Lordship. But indeed, Your Lordship. Indeed, Your Lordship. To answering to this issue, whether an A is capable of committing a criminal offence, I would contend that A is capable of committing a criminal offence, but the liability would strictly fall on the respondent for the act committed by A, Your Lordship. Because in the first case, it was portrayed in obscene manner. They do not know whether it is obscene or not. But the MS Creative Limited have known that it is obscene in manner, Your Lordship. But they have published because it contains the Lydia's face, who's the famous actress of Indiga. If she has been portrayed in the digital artwork, definitely for her huge fan base, the Indeed not, Your Lordship. The vicarious liability will apply to the employer and employee. For this, apparent liability can be imposed, Your Lordship. For the act of Raha, respondents shall be held liable, Your Lordship. And in second case, the A fulfills the mens rea of the user, Your Lordship, by accepting the command and acting according to it.
Tell me something. Do you admit the fact that AI, Raha, is capable of thinking on its own?
Indeed not, Your Lordship.
Okay. Are you admitting the fact that
Your
AI,
Lordship,
forget that, forget
indeed,
that.
Your Lordship.
He has this habit of simply standing up and down. Forget it.
Indeed, Your Lordship.
Do you admit the fact that AI has this ability to generate information?
Indeed not, Your Lordship. It creates by the inputs given to it.
Let me assume that inputs are given for 1 year.
Indeed, Your Lordship.
After that, do you admit the fact that AI by its very nature is capable of generating new things?
Indeed, yes, Your Lordship.
Okay. Then, if AI is capable of creating new things, where is the question of mens rea of its founder?
Indeed, Your Lordship. Before 1 year itself, it was given by the user only, no, Your Lordship.
Is that your case?
Indeed, Your Lordship.
So your case is that these people input information relating to Lydia with the intention of showing her in an obscene manner, is it?
Indeed not, Your Lordship, but it has created it in an obscene manner. They would have stopped from being published, Your Lordship. But they have published it for the commercial purpose.
Stop there. With this algorithm available, is it possible for the founder, if I'm the founder, is it possible for me, in view of the algorithms available, to stop AI.
While processing, it cannot be stopped, Your Lordship. But after getting that output, they can, it resembles the face of Lydia. They can stop from being publishing it, Your Lordship.
Good. So we're talking about two separate things?
Indeed, Your Lordship.
Okay. Where is the mens rea now?
Mens rea is not necessary for AA to commit a criminal offense, Your Lordship. Mens rea is for the respondent, Your Lordship. The AA fulfills the mens rea of the respondent.
Okay. I think you're logically wrong. You'll have to think through again. Thank you.
Much obliged, Your Lordship. Your Lordship, here the criminal offence stated was obscenity, Your Lordship. In Ranjit Udeshiv's state of Maharashtra, it was declared that it is not necessary. There are provisions in IPC that are silent on the same, like Section 292 obscenity, employing a strict liability stance on obscenity, going against the notion of well-established ingredients of criminal law, such as mens rea, therefore is notable, which means the intention of the accused is not taken into account at all, even if there is an unawareness of the contents of the impact object is being obscene, Your Lordship. So mens rea for committing a crime of obscenity is not necessary, Your Lordship, and AA have committed it, Your Lordship. I would conclude by saying AA is capable of committing a criminal offence. If the bench is satisfied, the council will conclude it with a prayer, Your Lordship. Much obliged, Your Lordship. Council's prayer. Wherefore, in the lights of the facts of case, issues raised, arguments advanced, and the authorities cited, it is most humbly and respectfully prayed that this Honorable High Court may be pleased to declare that an artificial intelligence humanoids like Raha shall not be the author of the generated artwork under the Copyrighted Act, Your Lordship, 1957. To declare that the artistic work created by Raha did not pass the test of originality under Section 13(1)(a) of the Copyright Act, Your Lordship. To declare that the usage of the copyrighted material to train an AA cannot be considered as a fair dealing, Your Lordship. To declare that an AA is capable of committing a criminal offence, Your Lordship. To hold respondent is liable for the act of the artificial intelligence Raha, Your Lordship. To issue an order granting permanent injunction against the respondent for the use of Lydia's copyrighted work under Section 55 of the Copyright Act, Your Lordship. To direct the respondent to pay a sum of 20 lakhs as a compensation under Section 55 of the Copyright Act, Your Lordship, for the acts of the infringements committed. And pass any other order it may deem fit in the interests of justice, equity, and good conscience. All of which is humbly prayed. Much obliged, Your Lordships. It was pleasure arguing, Your Lordship.
Council seeks permission to approach the podium. Much obliged, my lords. Lords, may it please this Honorable Court, this is the Council appearing on behalf of the respondent in the case of Lydia versus Mrs. Creative AI Limited. Council seeks permission to address the bench collectively as my lords. Much obliged, my lords. My lords, if my lords have already perused the facts of the case, may the Council please move to the issues in hand directly. Much obliged, my lords. My lords, in the interest of justice and in the account of necessity and brevity, this honorable bench is empowered to address the 4 issues as given in the proposition, whereby, my lords, I'll be dealing with the first and fourth issue pertaining to authorship under copyright and the criminal liability or attribution of criminal liability for AI. And the second issue and third issue pertaining to originality and for doctrine of fair usage, my co-counsel will be dealing, whereby the researcher shall be assisting with other regards, my lords. My lords, may the Council, before proceeding, my lords, the Council would like to give the set of judgments which it might be relying upon. Both the copies are of the same judgments, my lords. If it may please this Honorable Court, the Council may like to proceed with the arguments of the first issue. Much obliged, my lords. My lords, pertaining to the first issue of whether the copyright law of Indica must recognize artificial intelligence humanoids like Raha as the author of generated works, the council would like to humbly submit that yes, indeed, my lords, the copyright law of Indica must recognize artificial intelligence humanoids like Raha, and the council shall rely upon a three-limb basis to substantiate the same, my lords. My lords, pertaining to the first limb of my arguments is that, my lords, there is certainly a lacuna in law itself. My lords, the provisions of copyright law in this particular instance are certainly to be given a purposive interpretation in this regards, my lords. My lords, there's been a lot of instances whereby this honorable court or Supreme Court has in time and time regarded that whereby when there's a lacuna, when the court is not able to determine the exact provision of law itself, it has to stick to the resort of intent of legislature when it was framing the provision. Therefore, my lords, if I may please rely upon the judgment of Kanta Goyal vs. B.B. Pathak, with a citation 1977 SCR 3412, which is in the compendium as flag number 15, my lords, the exact words of the judgment read as, the intention of the legislature is derived by considering the meaning of the words used in the statute with view to understanding the purpose or object of the enactment itself. Certainly, my lords. My lords, to answer the same, my lords, if I may please have your attention to section 2D, my lords, of the Indian Copyrights Act. My lords, the provision reads as follows. My lords, it reads as author means. Now, my lords, if we look on to this particular, and then they have a set of categories, other, my lords, which the council had to contend earlier. However, my lords, author, if at all the intent of legislature was to have only a person as an author, it would have specified author who is a person means. However, my lords, it did not do so. And my lords, there have been a lot of provision where they want that particular person to be a person. My lords, they want owner to be a person, but author need not be a person in that regard. My lords, the jurisprudence, even though it's not binding upon this honorable court, as its 16th chapter deals with legal personhood. My lords, it has two kinds of people under that. One being natural persona, which is all humans who are made of blood and flesh, which the council it's a settled proposition of law that we cannot be seeking persona under that regard. Second category would be juristic persona, which is regarded by judicial review. And third character is artificial persona, my lords, which is given to companies and corporations. My lords, the councils would like to seek this honorable court's attention to the fact that we are seeking refugee under juristic persona in that regards, my lords. My lords, there's been a lot of cases, including the Nagaraj judgment, whereby animals were considered as persons for the welfare of animals in that regard. My lords, as my lords had already pointed out, even in the Ram Janmabhoomi case, we did hold that Lord Ram himself was a juristic person. And be it a plethora of judgments, my lords, in the interest of a particular person or a particular group of people is concerned, we have allotted juristic persona in that regards. Therefore, my lords, even if we take in section 17A, it too specifies that it's just the author. It does not specify that the author shall have to be a person. However, my lords, when they have defined owner, they have specified that owner who is a person. Therefore, my lords, the intent of legislature in this regards is certainly clear that they certainly want the author need not certainly be a person in that regards. Therefore, my lords, if I may please have your attention to the judgment of Sulamangalam R. Jayalakshmi versus Meta Musical Chennai, with a citation 2000 PT 681, given by the Honorable High Court of Judicature of Madras in this regards. My lords, it's given in the compendium of flag 16, my lords. My lords, the exact paragraph 21 of the proposition reads as such, my lords. It specifies the essentials required for a copyright infringement. My lords, it makes only two essentials. First one being that the subjective, the two works which are concerned have to be similar in nature. My lords, it's to be noted that the trial court had made an observation that it did just resemble the work. However, my lords, there is a difference between works being resembling and then similar to each other. My lords, when I say that you resemble someone, it means that you have certain features of yourself which might look like someone. But then when I say you are similar to her, you're identical to her, I mean that you both are the same. That's why we call identical twins, which means that both people look the same way. We don't say it's resembling twins. Therefore, my lords, we are able to have a very basic interpretation of the word itself. And therefore, my lords, even though, my lords, the trial court had noted that it was just the resemblance, but still the judgment was certainly in the favor of appellants, despite of taking the notes. Therefore, my lords, the company was certainly in a place on that regard. My lords, the second essential as prescribed in the judgment itself is for them to figure out the source. That is, the source can either be direct or indirect. In this regards, my lords, the sources have certainly not been specified. My lords, issue number 1 only, my lords. I'll be dealing with issue 1 and 4 only. In this regards, my lords, the council, whether author can, the term of author can be attributed to AI or not, my lords. On that, certainly, my lords. That's certainly, my lords. But then the council will not be able to rebut the arguments because they'll be able to produce only in. We are subjected to stick only to the rebuttals. So the councils believe that it is the right place that we utilize our time and rebut at the right time. Much obliged, my lords. My lords, going ahead to the second essential of that, the second essential is that, my lords, it must be of the same source. My lords had already pointed out to the learned council on how does the AI work, what is the technicality aspect of that. My lords, the council being a client would like to have already explained to us how does AI work. My lords, the entire way which AI works is basically on a mechanism of RNN, which is recurrent neural network. My lords, the basic principle is that a bunch of data, my lords, is actually fed when they are into the research and innovation purposes. My lords, upon developing an AI, all these sources are fed together. My lords, based on all the sources which are given to it, it develops a proforma. That is, on this perspective is what and when a user, my lords, asks for a certain input, based upon the input which it requests, it fetches the relevant one, fills in the proforma with the creativity which the user needs. Therefore, my lords, the creativity or selection, the judgment it has exercised over here, its capability on it being fed on that regard, my lords. My lords, it specifies, and in this instance, my lords, the council like to specify that it was a Facebook post indeed, my lords. My lords, if we may see all AI bots like Gemini, which is owned by Google, or ChatGPT, or Bing AI, all these AIs, my lords, are specifically resorted to one particular date. Therefore, my lords, if you open the software itself, it says that this AI is updated only till January 2020, January 2021. AIs cannot function on a day-to-day basis, my lords, on the input which is being given. But then, my lords, this particular post was a social media post. My lords, on a single day, more than 200 billion posts are certainly put into AI. It is not possible for AI to grow on a daily basis and take everybody's post and feed into itself. Therefore, my lords, since it's a social media platform, which it's certainly been, there is not a possibility that it might have had that as a source. My lords, the clear fact, even the basic source of data which is being given to it, my lords, the council had misrepresented the fact that it has already been given 2,000 Getty images from the source. My lords, the proposition is certainly got nothing like that. However, my lords, even if we regard that it has been given a bunch of labeled data, my lords, it's clear that it is all labeled data at the end of the day. However, my lords, this specific interpretation which the council has put forward, my lords, makes it clear that every feature, my lords, the AI itself determines the shape. However, my lords, if we see, if I'm asked to draw a face, I know a face would certainly be circle in shape. That doesn't mean that I have taken an idea from somewhere. It's something which I've been fed with. Therefore, my lords, AI has been filled with a basic proforma of when I ask you to generate a picture of a woman, this is what you will have to do. And then it takes all the 2,000, 3,000 images as its reference or whatsoever it's being fed to, and it takes the shape of an eye. And my lords, each and everything is certainly from every individual picture. At the end of the day, my lords, the council had even pointed out that if at all they've generated the work, they could have kept it inside. Why did they put it and wanted to make it commercial? My lords, it's very clear that if at all she's a very famous actress, when the portrait was generated by AI, would have been able to figure it out. It is not a big deal for a company to go and ask a no objection certificate before her and get the work in print. The reason is that it did not resemble in the first place. As my lord had already pointed out, it's just for the sake of fame she's putting forward this entire case, and she wants to remain in topics or in that regards, my lords. My lords, going ahead, my lords, and the very basic premise which the council would like to put forward is that, my lords, there is a possibility of joint ownership, my lords. My lords, even if we regard AI, argument of purposes, my lords, if we regard AI is certainly not to be given a legal persona, my lords, on a juristic persona, if it's given so, there is a possibility of joint ownership always. My lords, as defined in section 2Z of the Copyright Act, which talks for joint ownership itself, my lords, it specifies that both of the works, if I may please have your attention to flag number 17 of the compendium, it is a judgment of the Institute of Inner Studies by Charlotte Anderson. Vide citation 2014, 57 PTC 228, whereby the Honorable High Court of Delhi had specified the essentials of joint ownership, my lords. My lords, it specifies three basic essentials, my lords. First one being a collaboration. My lords, the council would like to substantiate the same way when it's stating the essentials. My lords, collaboration in this regards is the company. My lords, the company, the client in this instance, our client had made the robot in this instance. Therefore, my lords, if at all we give joint ownership for the company and to Raha, my lords, let the authorship be invested upon Raha, who shall be the second author. However, my lords, let the company, who is the inventor of the Raha itself, be given the first owner. My lords, automatically, if they are given first owner, it would imply that they are the first author too, as owners are certainly authors. Therefore, my lords, let second authorship be given to Raha. And however, my lords, if my lords certainly deny this contention, and if at all the AI is just given, the company is just given the rights also, the council will be more than happy indeed, my lords. Because at the end of the day, we want the company to be given the copyright for the works which is generated by AI and the AI itself, my lords. My lords, if I may please have your attention to flag 20 of the compendium alone, my lords. My lords, if I may please have your attention to flag 20, which is given in the compendium, my lords. It's a report by Rajya Sabha, my lords. My lords, this topic did come for discussion, whereby, my lords, the Rajya Sabha on its committee report had remarked that it is high time that we accommodate AI into our lives. My lords, when the Copyright Act was enacted in 1955, nobody possibly saw it coming that AI will probably take over the entire world. But then, my lords, fortunate or unfortunate for us, it has certainly done so. My lords, very simple example, the council has certainly, on a pragmatic explanation, my lords, in the given compendium, since we were not permitted to use internet before this code, my lords, we have attached a few screenshots at the end. If I may please elaborate what the screenshots are about. We opened an AI, my lords, which is Gemini, owned by Google, which is certainly an AI software. We took a poem of John Keats, my lords, who is a very famous author indeed. We took a poem of John Keats, and then we asked AI to rephrase and restructure it in a way that the essence of the poem is not lost. It did restructure and give, my lords. Before getting it, my lords, the same work was put into a plagiarism software. It said that the work was 100% unique. However, my lords, when you go for copyright registration, it is to be noted that plagiarism is not checked. However, my lords, even in that regards, it is not fair for a person, just because AI is not able to stand up for itself and make it regard, it is not that you created the work by yourself and you want copyrights for it. Therefore, my lord, if that rephrased poem is taken and went to a copyright registry and said that it is my work, nobody would certainly obtain so. Nobody would certainly object to the fact. And then we judge this person that this person is very creative, but deep down we all know that it's a small 4-room thing which he's doing, whereby he's using the AI's help. But this can be avoided, my lords, if the works which are generated by AI are certainly given copyrights. My lords, it's not fair for humans to just be stealing the works of a robot just because it is capable of doing so. That's the contention which the council would like to humbly submit, my lords. My lords, even in that regard, my lords, there has been a lot of free AI detectors. My lords, AI detectors, if we just give the document inside, it says that how much % of work is being generated by an AI. So we do not have to worry upon that creativity either. But then when it comes to copyrights case, my lords, it's evidential that we do regard them as persona, we give them a legal persona, which would automatically entitle them as authors in the act. My lords, a lot of cases, including Maula Baksh, my lords, whereby we considered mosque as person. Whereby, my lords, even in Ram Mandir Janmabhoomi case, Mahan Suresh Das, we did consider Ram. My lords, juristic persona is certainly given by this honorable bench, my lords. It's certainly up to the judiciary for them to appoint, and that's the reason we are even seeking, my lords. We know that we are not a possible thing under artificial company, because even in that regards, we are just a company. And natural persona is not possible because we are not made up of blood and flesh either. Thereby, juristic persona, whether the Nagaraj judgment or the Maula Baksh judgment, we have made it clear that the judiciary is very well empowered to give legal persona if the honorable bench deems necessary so.
Tell me something. Does your company recognize Raha as an individual entity of its own?
My lords,
Forget what they say.
Sorry.
What do you say?
My lords, as ignoring their perspective, my lords, when it comes to the office instance, my lords, it is treated as a separate individual. It works by itself and it is autonomous in nature.
Right. Step 2. If you treat it as a separate individual, who should have filed for copyright?
We should have certainly done.
No. The separate individual should have filed for copyright. Why did the company file?
Certainly, my lords. My lords, in this instance, it's to be noted that Dr. Evans had created the robot in this instance. And then the owner, my lords, this AI robot, my lords, is an innovation by the company indeed. Thereby, my lords, if it was that particular individual, however, our current law does not recognize it. My lords, if we go through the proposition, it makes it clear that we did apply for register of copyrights. And then they rejected on the ground that AI is not a person under the existing law. We have certainly referred for appeal in that regards, my lord, which is very well in the proposition. But however, we are not referring to that particular matter, and we are just here to defend ourselves that we are not ready to pay for the compensation. That's the thing, my lords. It's on the proposition that on that particular matter, we did apply for register of copyrights, and they declined it on the ground that AI is not a human. As per the existing provisions of law, we cannot give you the thing. We have appealed the judgment, my lords.
Easier to defend yourself rather than to make out a case.
Since we are the respondents in this case, we are here to do so, my lords. In that particular appeal, my lords, we'll get legal persona or that particular thing. My lords, Certainly, my lords. My lords, it was again, it was just a two-way thing which the council wanted to do so, my lords. If at all the first argument is certainly rejected, if at all my lords are very well convinced with interpretation that way, the council will be more than happy on to assist on that regards, my lord. My lords, this court is very well, even the Supreme Court in Visakhapatnam state of Rajasthan took the extra step of giving guidelines to the legislature, my lords. But then certainly, my lords, the council is very well aware with the Rajya Sabha Standing Committee report, the legislature is indeed would certainly accommodate AI into the purview. But then in this instance, since copyright infringement is in high notion over here, than the legal persona, the council is just here to defend themselves from the current case, my lords. May the council please move to the last issue on hands, my lords?
Council, I have two questions.
Certainly, my lords.
One is, in your research, have you found out similar kind of situations where an AI has committed an offense? Or, if I have to put it this way, the probability of an algorithm having an inherent bias while writing the algorithm, or after writing an algorithm, the probability of again inherent bias while training the AI. Have you referred to any cases? I have three illustrations. If you say it is not.
Certainly, my lords. My lords, on that particular instance, on the research which we have done, my lords, on even if we take copyright itself into the record, Zari of the non-judgment is very predominant in nature, my lords. My lords, the US copyright registry would have certainly got it registered, but then they would have revoked the registration on the same ground. Going ahead, my lords, AI Raghav is developed in India itself. AI Raghav is an application of India whereby that was asked to generate AI works in that instance either. Based on all those researches, my lords, this were all 2020, 2021. But then, my lords, the clear fact that AI has started to, my lords, the thing is very simple. We all draft.
Question is also very simple. The percentage of bias while writing an algorithm program, is there any ethical standard universally followed while writing an algorithm or while testing an algorithm while putting it to action?
My lords, getting into the technical aspects of this particular.
Is there any ethical rules?
My lords, algorithm in this particular instance, my lords, the algorithm which is being given to it is basically a bunch of label program data which is given in the proposition, my lords. So every data which is.
I'm not asking the proposition. I'm asking you while doing research, have you come across situations where algorithm bias has happened? And then today European Union is marching towards a committee to have ethical standards to see that every time an algorithm is used or a training is being given to AI, what is followed? Are you aware of it? That's what I'm asking.
Well, as the council would like to certainly be enlightened on that, but then we would request a little time on that regards for a researcher to get back on it and deliver at the time of end.
So you're not aware of it?
Certainly not, my lords. Since it's on the technical aspect, the council will be more than happy to engage in a legal perspective, but since it's technical, the council will just take time and get back.
The case is not purely legal.
Certainly, my lords. The council would like to get back on that particular regards, my lords, with the researchers' help. My lords, moving ahead to the next submission, my lords, the very basic contention is that, my lords, all the human resources, my lords, the way they evaluate is basic. The way they judge someone is through their resume. And even though, my lords, the resume is not just dropped to them, it is sent through an email. My lords, if we see an email being drafted and the way it is even drafted, we would be able to judge the glossary skills of one particular person. But however, my lords, in this particular generation, when AI has certainly infused into everyone's lives, we are asking AI to generate a perfect email whereby it just fits in all the contents of your resume to one particular email, and that email is being sent. Thereby, my lords, even human resources on that particular regards would not be in a position for them to evaluate a person on that particular regards despite of that instance. My lords, going ahead, if I may please go to the next issue in hand, my lords, if my lords are convinced. My lords, the last issue in hand, which is whether an AI is capable of committing a criminal offense or not. My lords, the council would like to humbly highlight that AI is certainly not capable of committing a criminal offense. My lords, the learned council had certainly pointed out that, had very certainly pointed out the perspective of law that two elements are essential, that is mens rea and actus reus, and everything is fine. But then they said actus reus alone is enough, and the mens rea is certainly put on the company in that regard. My lords, it's certainly not a very a plausible argument which the council could have probably made. Therefore, my lords, if we cannot at the end of the day put AI behind bars, and there is no purpose on doing so, because at the end of the day, even if it comes out, it might not even know what's legally right and legally wrong in this particular instance. However, my lords, it's to be noted that it lacks intention. My lords, a very basic example which the council like to give us there, my lords, a computer robotic arm program, for instance, let it be generated, my lords. The basic movement it does is this, which is the basic movement which is being programmed to do so. Now, my lords, if a person puts a knife in this hand, and certainly it's probably pure, it's getting into someone, it stabs someone. Now, the person who puts the knife is certainly to be taken into consideration, but not the AI board itself, because they know how to use this board. Therefore, my lords, it's on the user who is to be given the responsibility than the company or the board in themselves. They know this is, my lords, it's very possible that if an AI is being fed 2000s and 3000s databases, I can even feed it the constitution, I can even feed it all the legislations and ask it that if at all you are asked to do anything against the said provisions, abstain yourself from answering. It's very plausible thing to do. And thereby, my lords, again, it's again on a very notion that it is capable of identifying, provided it's being done so. My lords, again, my lords, an offense in that regards, my lords, an offense, can I know in what form?
The company can be guilty of an offense.
Certainly, my lords.
Then why not an AI?
My lords, again, my lords, it's not an artificial person indeed. It does not, my lords, even if you say since companies, there has been a lot of judgments where we state for criminal liability, we impose it on the directors of the company, stating that the company operates in the mind of the directors, imposing the mens rea on them. But then, my lords, if we grant them juristic persona, it is not possible for us to be giving that particular mens rea to anyone, because it's the robot itself exercising its judgment. And that puts us in a place, my lords, for us to conclude that companies can indeed take criminal liability, but not AI bots itself.
I think you're going against your previous statement. You said AI cannot judge.
My lords, AI on that regards, on what is being given to, can exercise its judgment on its
Okay, if I
regards,
put
my
it
lords.
this way, the person who is writing an algorithm, in this Raha's case, now he is interested in Lydia, and he wanted to see Lydia in a swimsuit, right? And this is reflected in his algorithm unconsciously, or in his subconscious mind, he wanted to see Lydia in a swimsuit. And when he wrote the program, he forgot to delete that particular portion, which randomly came, because you are unaware of a committee which will look at the ethical standards while writing an algorithm. Why that could not have happened in this particular situation? When there are so many images of other actresses, other stars, why specifically Lydia, even a resemblance?
My lords, as my lords had already pointed out, it might be again, my lords. It's an assumption. Therefore, my lords, even the council could put forward an assumption that it has already been fed with, and it's not the face of Lydia. And the council could even assume to the fact that Facebook posts are certainly not given so. But then, my lords, the proposition restricts itself to the fact that what was being given to was certainly not discussed.
Exactly. That is what I'm trying to make it clear, that if in the algorithm itself, if there could be a trace of an intention, which is now coming as a form of an artwork, specifying Lydia, can't you draw an analogy there?
My lords, on that instance, my lords, when we are as you
because in US this has happened. US tried to use an artificial intelligence to prosecute people who were violating traffic norms. But after a research being systematically done, they found out that the programmer, the person who wrote the algorithm, he was biased towards a particular color. So almost out of 100 cases, 99% or 95% of the cases were focusing to a particular race.
My lords, to even give a practical example which happened in our own state alone, my lords, I guess my lords would have been aware of the famous actress Ms. Rashmika Mandana, whereby her face was certainly, through the mechanism of deep fake, her face was
that's a different thing.
Yeah, certainly, my
that's
lords.
a different thing.
The criminal intention.
Please don't
again,
mislead. Yeah, that's a different thing,
certainly,
technically.
but then the intention is certainly with the user, but not with the AI bot itself. And it is not possible for us to criminally attribute them. It is the user who should have taken necessary efforts to not do so that act, but not the AI bot. And that particular instance, my lords, shall probably put forward in a place
if
where...
I put it this way, are you trying to say that AI will never commit a mistake, or AI is so well trained, the algorithms are so well tested, that there is no scope for culpa itself?
My lords, it's
then you will go against the concept of deep...
My lords, on that instance, my lords, the subject itself is very evolving in nature. 3 years, 4 years earlier, we did not even see something like AI would probably come into courts, and now it's for discussion whether they could be given persona. My lords, again, it's a very possible thing that this honorable court is railing on, and that the clear fact that it's a possibility is certainly the council would not be able to assess.
Still, that is not an answer.
My lords, again, it's a possibility which my lords are certainly pointing out. The council would like to rest on that regards, my lords.
Okay, let me ask you a slightly different question.
Sorry, my lords.
The Raha is capable of taking decisions? Yes?
My lords, decisions on what regards, my lords?
Whatever
Anything
you
in
want.
specific.
Anything advantageous to you.
Done, my lords.
Okay. That results in some good?
It could, depending
Okay.
upon the user's prompt, my lords.
Let us assume that it results in something good.
Certainly.
The credit comes to Raha
My lords, if the
or it comes to the company?
my lords, either way, if it's being given to the company or
It's
to
good.
Raha, it's
It's
good
good.
only. It's good
Right.
only, my lords.
Now let's assume similarly Raha makes a mistake and it results in something that is dangerous to the public at large. Who takes the liability?
My lords, the company indeed could take, my lords. My lords, it's because at the end of the day, since the council had specifically referred to joint ownership in this regards, my lords, the Raha is owned by the company. And for any acts of Raha, the company could take accountability in this regards. Therefore, my lords, it would be very blatant of us to say, for any good it does, we can take credit, and for any bad it does, we cannot take credit. Therefore, my lords, we would take responsibility in that regards.
So are you trying to just split hairs on an academic note by saying it's actually not Raha who's liable, it's actually us who are liable? Is that what you're trying to say?
My lords, it's certainly not the contention which the council would like to put forward, my lords. My lords, Raha at the end of the day is capable of just doing what the user is capable of, what the user is asking it to do so. But then, my lords, we have fed in the basic algorithm, as my lords had already pointed out. The basic algorithm which is being given to it, it is something which is follows. And my lords, it depends upon every user prompt which is being given to it than the Raha's algorithm itself in that regards. If you have no further assistance, the council will like to rest the case and let my co-counsel take over.
If the bench permits, may the council approach the project. Much obliged. May it please this honorable court, this is the co-counsel appearing on behalf of the respondent in the present case. If the bench permits, may the council proceed with the second and third issue at hand. Much obliged, Your Honours. Your Honours, while dealing with the second and third issue at hand, issue number 2 deals with the test of originality and whether Raha passes it, and issue number 3 deals with whether Raha falls under the fair use exemption. Your Lordships, if the bench permits, may the council proceed with the arguments. Much obliged, Your Honours. Your Honours, while dealing with issue number 2 regarding the test of originality, it is a well-known fact, Your Lordships, that section 13 very clearly states that original works will be given copyright protection. Your Lordships, the section fails to provide for a definition of what original would really comprise, and therefore various case laws have been put out by the Supreme Court and by various high courts to determine what originality is. And the council, Your Lordships, would like to refer to the Supreme Court case of R.G. Anand versus Deluxe Films, which is flag number 3 of the compendium submitted, AIR 1976 SC 1615. Your Lordships, what this case law basically brought in or introduced the concept of dichotomy of idea and expression to Indian jurisprudence. Your Lordships, what this concept in the most easiest terms would imply is that an idea is not protected under copyright, but when this idea is expressed, it will be given a copyright protection, and when that expression is again as derivative works re-expressed with certain amounts of creativity, those separate works also will be allowed a copyright protection. And that is what the council is claiming here, Your Lordships. Your Lordships, I would like to clarify before this court that being the respondents in the present case and our appeal being pending before the registry of copyrights, we are entitled here only to defend, and that's why the council would like to stay firm on that regard. Your Lordships, with the dichotomy of idea and expression being laid down before this court, if we relate it to the present facts at hand, Your Lordships, Miss Lydia in the present case has had an idea to maybe post a picture on the internet, which she has done so. Therefore, expression of that idea has taken place. But your lordships, later on, the Raha being allowed various databases, as my co-counsel itinerated, that is using the recurrent neuronal network and transformer models. What Raha did was it regenerated a photo or a painting of which one of the databases or one of the inspirations or derivatives was Miss Lydia's picture. Your lordships, the council would like to reiterate that the trial court did an investigation and very clearly said that there was resemblance. Now, your lordships, there is a very stark difference between resemblance and being identical. Resemblance, your lordships, if it is proved before this court that resemblance has taken place with modicum of creativity, that is, if certain amounts of creativity has been exercised, then that would imply, your lordships, and go without saying, that Raha passes the originality test. Only, your lordships, if the investigation stated that the portrait or the woman in the painting was identical to Miss Lydia, would it have been a matter of concern? Your lordships, with the word resemblance being used, it is evident, your lordships, it could have been resemblance of anything. Maybe just one nose, maybe just the eyes, maybe even the eyes shape of Miss Lydia was resembling. That in no way, your lordships, allows the appellants to come to the conclusion that the whole face was resembling. Because the trial court in its wording has been clear that yes, certain resemblances are there. But to quantify it and to justify it on proper, or to say that it's the whole face, would go beyond the factual matrix, your lordships. That would be the first contention of this council. Your lordships, I would like to put out an illustration before this court, and that is while dealing with celebrities as the appellant in hand, your lord. Certainly, your lordships. Certainly, your lordships, but while talking about resemblance, resemblance is not identical. Therefore, if she resembles Miss... Certainly, your lordships. What the council was trying to reiterate, that it could have had resemblance to another person as well. One person can resemble multiple people, but it cannot be identical to multiple people, is what the council was trying to portray. Your lordships, moving to an illustration for better understanding, if we take, say, a very famous superstar, for example, your lordships, in the country of India, we have the superstar Shah Rukh Khan. He posts on social media, your lordships, continuously, and he has fans who, in fact, they don't even resemble. They just copy off the pictures that he posts, and they post it on posters, advertisements, t-shirt, cups, and they sell it, in fact, as fan merch. There is proper monetary gain involved. But, your lordships, there is a procedure manual by the government of India in 2018 where they said in paragraph 10 of that procedure manual that while dealing with celebrities, no prior permission is required, because these are people that want public attention. And, your lordships, this painting, in fact, what it itinerated, what it eventually did was it brought Miss Lydia into publicity and into public limelight. Now, your lordships, a question would arise of the appellant's regarding the malleate or regarding the swimsuit allegation, how it was obscene. And, your lordship, the council would like to clarify that that was mere a misleading of the bench that the appellant was trying to do, as the word malleate, your lordships, can be understood or has various meanings. It obviously has the meaning of the swimsuit, as my appellant mentioned, but what the other meanings, your lordships, of a malleate would be the dress of a ballet. A ballet dancer also wears a malleate. In Spanish dances, the costume that Spanish dancers wear are also malleates. Therefore, your lordships, when that wording is being used, they cannot use one definition that is advantageous to them and be like, oh, for this reason there is obscene content. And, your lordships, on that note, the council would also like to reiterate on the facts. The facts definitely say malleate, which has various meanings, as I said earlier. But what the facts also say, your lordships, if I may read verbatim, is that the artwork Beauty Queen portrayed the picture of a poised and confident woman adorned in resplendent exuding timeless elegance and intelligence and embodying a harmonious blend of classic refinement and contemporary allure. Your Lordships, every word, every adjective that has been put in the factual matrix is completely the opposite of what obscenity and vulgarity is. It is glorifying the person in the picture, and therefore, even if we were to take that the face was of Miss Lydia, we are promoting her, we are showing her in such grandeur. So the question as to why they are bringing in ambits of obscenity or vulgarity and questioning the bot, Your Lordships, remains baseless. Your Lordships, moving on, Your Lordships, there is the case of Gleeson versus Den, a very landmark judgment by international courts, which is flag number 9 of the compendium submitted. Your Lordships, what this case held in an illustration put on by the court itself was that if one person works hard enough, walking down the street, collecting names of people and making like a neighborhood registry, that would amount enough hard work and creativity to entail a copyright. Your Lordships, in the present case, the AI, it is so advanced, Your Lordships, and in fact it uses so many databases that I would like to clarify the technological aspect, which again my learned opposing counsels attempted to mislead, Your Lordships, while dealing with labeled data as Raha uses, as the facts are clear on. There's the concept, Your Lordships, as my co-counsel iterated, recurrent neuronal network and transformer models. So how this system works, Your Lordships, is that a lot of data, unauthorized or authorized, unauthorized for the purpose that they will fall under the fair use exemption while training, it is all fed into the system via a label of what it is. And it falls, Your Lordships, into a common box. And upon that common box, when the AI is asked to do something or to generate something, it will evolve from that common box where all the data is stored. It will recreate, it will think, analyze, Your Lordships. Your Lordships, the council would also like to bring into the attention and cognizance of this court that the appellants at hand kept mentioning about how generation is taking place. Your Lordships, the council would like to clarify before this court that the proposition is very clear on the fact that this is an autonomous AI. Your Lordships, an autonomous AI is very different from a generative AI. Generative AI, Your Lordships, works on a prompt. That is, we ask, as in ChatGPT is generative AI. We ask the prompt, we say, give us this, and it will give you that. Autonomous AI, Your Lordships, they have one sole purpose, and they will, after data is being fed into them, after it is being told that, oh, this is what you have been made for, after that, it is their autonomous creativity that brings out the paintings in case of Raha, Your Lordships, all of which goes to prove that Raha exercises creativity as the modicum of test in the case of Eastern Book Company complies us to do, and has originality in technological terms, Your Lordships. Because this is not something we would have comprehended a few years ago. If we've told our grandparents that in our generation there will be robots that will be making paintings, it was almost a thought they would have not imagined. And we've come to that level of originality and that level of transformation. And with that being creative as well, Your Lordships, the council would like to submit my argument saying that Raha definitely passes the originality test. If the bench has any questions to me regarding the originality test, I would be very happy to address them. Certain, Your Lordships. Your Lordships, the sweat of the bro test asked for 3 essentials, and that is skill, judgment, and labor. All of which, Your Lordships, remain satiated in the present case. Skill being, as I said, the transformation and the invention, the bot, the functioning of the bot itself is skill in a way. Judgment in the sense that we are only providing, we are only feeding data. To act upon the data is on the AI, as it is an autonomous bot. Skill and labor, of course, Your Lordships. While it is bringing in, while it is putting in, or while it is bringing out the painting as beauty queen in this picture, labor is also put into forth. I would also like to clarify, Your Lordships, that in the case of Eastern Book Modak case, Your Lordships, the court held that sweat of bow doctrine should be read with a modicum of creativity. And therefore, your lordships, both the tests being satisfied would imply and go without saying that Raha passes the originality test. Certainly, your lordships, the skill here is that we are allowing a person who is not a real person. Your lordships, when we are talking about people like us, when we go to school, we are fed, like we are taught A, B, C, D. And that is a form of input or data that we are consuming. And as we go on, your lordships, because we have the intellectual capacity, we have feeling, and we are such the best beings, in fact, or the beings that have the mentality and feeling, we are able to put in paintings, your lordships. So when an AI, when a robot that is designed to by itself bring out paintings, just by us feeding little information and data into it would obviously require a lot of skill, your lordships. The framing of the algorithm in that procedure itself would require tremendous skill. Your lordships, what the council is trying to itinerate, that firstly it would amount to that, and secondly, when the skill is being put to use, because it's an autonomous bot, that's your lordships, that is the distinction while dealing with generative and autonomous AI. Autonomous AI, your lordships, after we feed a certain amount of data into them, they act on their own. They act, in fact, as humanoids, as humans, simply without maybe feeling. Therefore, your lordships, firstly, it may have been the skill of the person who wrote the code, but later on, in a certainly, your lordships, what the council...
What would be your suggestion, submission?
Certainly, your lordships, even if we were to go by the book as to what AI is, what the originality test is right now, in the context of AI or in the context of any work, artistic work in general, AI satisfies the test, your lordships.
New conceptual tools which you would suggest?
Certainly, your lordships, as we are the respondents, if the bench permits, the council would like to propose of what can be put, certainly, your lordships. Your lordships, so while dealing with AI, what should be realized is that there is a difference again between autonomous and generative, and that technological aspect should be put into a lot of consideration. And therefore, your lordships, when a test is being laid out, firstly, your lordships, there is no proper test of originality. The legislation itself does not stipulate for what it is. So I think firstly what the legislation needs is a proper mandated originality test, so all courts can abide by that. And secondly, your lordships, it is very pertinent to note that while dealing with works of people and while dealing with works of AI, the nuances will be different, and the courts must take consideration of the same, your lordships, because while dealing with human beings, it is the skill of human beings from the very beginning. But when we're dealing with autonomous bots, it will first lie on the hands of the person who's making the code, and only later falls upon the bot itself. And that is what the council would like the court to take cognizance of. Of course, our prayer in this, before this court can only be dismissal as we are the respondents. However, your lordships, to answer the question is why I itinerated all of the following. If my bench is satisfied, may I please move on to the third issue, your lordships? I believe I have a time crunch, so I will keep my arguments very precise. Your lordships, while dealing with the fair use doctrine as stipulated under section 52 of the Copyright Act, the fair use doctrine, your lordships, has 4 tests, as my appellant counsels also itinerated, but I would like to bring out of how the AI would satisfy the case in the given hand. Your lordships, while dealing with purpose, the purpose of the Instagram post and the painting Rahab coming into picture, your lordships, the purpose of the Instagram post was to appeal, was this celebrity who wanted to showcase to her fan followings or to appeal in an entertainment sector. The sector itself is different. Your lordships, commercial gain, but in different sectors. The actress works for the entertainment sector for that amount of people that would want to look at an actress or that maybe are interested in movies. But your lordships, while we deal with AI as such, this is a whole technological sector. Therefore, the purpose of the post and the painting would remain very separated, because what the painting attempted to do was show the world of how advanced AI can be, of what AI can do, and merely as a creative appreciation of technological advancement. It had nothing to do with the entertainment sector, for which purpose will be ticked off, Your Lordships. Nature. Again, Your Lordships, as my bench rightly pointed out, there is a difference between a social media post and a painting. A social media post, Your Lordships, is simply, in fact, the facts are very clear. It is a photo of Miss Lydia. All she did, Your Lordships, was stand in front of a camera and made it click, and she posted it. While dealing with the nature of a painting, Your Lordships, there is a lot of creativity involved. There is skill. We need brushes, strokes, or in this case, if it's an electronic painting, there was certain amounts of creativity involved, which was also appreciated by people, is what the facts is clear on. So, Your Lordships, that would imply that nature is ticked off. Amount, Your Lordships. Your Lordships, the appellant councils kept contending that only the face is what is similar and everything else is different and obscene. Your Lordships, and the council would like to stick to that argument, saying if the amount is only the face and the rest of the painting is, as the appellants claim, unique and in their case obscene, in our case not, that would imply, Your Lordships, that even the amount taken is comparatively small, ticking off that as well. And lastly, Your Lordships, effect on market. As I stated earlier, Your Lordships, the painting delivers to the technological market, while the post was for the entertainment market. Both markets being absolutely different and not even colliding at any given point of time, it would imply, Your Lordships, that the four-test doctrine under fair use will be allowed in the present case for Raha in this instance, and therefore that exemption can be used. Your Lordships, if I may simply conclude by quoting two very international famous judgments that are very similar to our given case. Your Lordships, firstly, it is flag number 2 in the compendium submitted, the case of Author Guild versus Google. Your Lordships, very similar premise happens here. They are dealing with Gemini, the AI bot. What happened here, Your Lordships, is that this AI takes books that is copyrighted, scans them, makes them easy for reading, and then publishes it on Google. So what the authors of the book said is that it is infringement of their copyrights. However, Your Lordships, the court held that because massive amounts of work is being put, that is, massive amount of data is being put into the system, and later it is simplifying it, that would amount that a regeneration has taken place in the present matter, and therefore it allowed the fair use doctrine. Another very similar matter, Your Lordships, is the case of Hyperoin Records versus Sawkins, 2005 WLR 3281, where, Your Lordships, a music composer, he takes other people's songs which have already been posted on social media or in any musical platforms, and he revisits them. Whatever he thought was wrong, any musical element that he wished to change, he makes additions, subtractions, a few modifications, and he reposts it as a new song. Here again, Your Lordships, the court held that the work will be original because some extra amount of creativity, alteration and modification has taken place, and that the fair use exemption can be used in the present case as well, all of which is humbly submitted before this honorable court. If the bench permits, may the council move on to its prayer. Much obliged, Your Honours. Wherefore, in the lights of issues raised, arguments advanced and authorities cited, it is most humbly prayed before this honorable court that it may be pleased to dismiss the present appeal and or pass any other order or judgment as this honorable court deems fit and proper in the eyes of justice, equity and good conscience. And for this duty of justice, the counsel for the respondent humbly submits and forever prays. It was an honor arguing before this court, Your Counsel.
Indeed, Your Lordship.
You will be covering co-counsel also.
Indeed, Your Lordship.
How penal code defines the term offence?
Your Lordship, the term, the council is not really, the council doesn't know the particular definition of the term offence, Your Lordship. Your Lordship, offence can be regarded as an act which constitute mens rea and actus rea, Your Lordship, which affects another. In the Indeed, Your Lordship.
Which law punishes, which law says an act committed by a humanoid is punishable?
We nowhere argued that the AA can be punished, Your Lordship. We want the respondent to take the liability and the respondent should be punished.
Linked with punishment.
Indeed, Your Lordship. Since AA is a humanoid robot, it cannot be punished through the imprisonment, Your Lordship.
It is not committing an offense.
No, Your Lordship. Only because it is not.
That is why we asked what is the definition of term offense.
As the Honorable Lordship has stated, anything for which a punishment can be granted is regarded as an offense.
That alone.
That is what the Honorable Lordship has stated. Your Lordship, the term offense was defined in the Indian Penal Code, Section 47, Your Lordship, which says that except in the chapter and sections, the following sections and chapters are provided. It denotes that the word offense denotes the thing punishable under this code are used under any special or local law as hereinafter defined, Your Lordship. So anything can be punishable, can be regarded as an offense.
That alone can be defended. Nothing else.
I think that is what the particular definition of stated, Your Lordship. Your Lordship, the council beg your pardon, Your Lordship, the council is not well about the term, Your Lordship, but our humble contention is that, Your Lordship, A cannot be punished through imprisonment or imposing a compensation, Your Lordship. So that itself amounts to the particular thing that we want the liability to be shifted to the respondent, Your Lordship, because they want the right, but why can't they take the liability, Your Lordship? With that particular point, can the council?
She is capable of committing the criminal.
Even the respondent itself stated that this particular sentence was stated by the respondent, the friendly counsel of the respondent. It is a knife is put in the hands of the auto working hand. So a knife is a tool. So knife can be only because it is a tool. It cannot be regarded as it cannot commit a criminal offense. So it depends upon the person who uses the knife, Your Lordship. So only because it is a knife, it cannot be regarded as it is not capable of committing a criminal offense. The similar way, A can be used for the criminal act. So it can be regarded that A is capable of committing criminal offense, and it depends on the person who uses it, Your Lordship. If Your Lordship is satisfied, then the council will move with the rebuttal. Your Lordship, the council accepts that the rebuttal, the respondent has stated that
This was also a part of the rebuttal. We thought this was also a part of the rebuttal.
Indeed, Your Lordship, the respondent has stated that we accept the particular point, what was the respondent has stated. The idea and theme cannot be copyrighted, Your Lordship. For instance, let's take the Ramayana. Ramayana is a story. So it can be regarded as an idea. The amount, how it was expressed by different people, that can be expression, and that expression can be regarded as a copyrightable word. But here, Lydia's face is not a theme, Your
Did
Lordship.
not infringe the copyright of Valmiki.
Indeed, Your Lordship. Your Lordship, our humble contention is Lydia's face is not a theme, Your Lordship. Subsequently, the respondent has stated that the appellant have came before the Honorable Court only for the fame, Your Lordship. No woman will reduce her modesty to get the publicity or fame, Your Lordship. Even she is an actress who is posting her photos in the Instagram or Facebook. The no term will always become no, and it never becomes yes, Your Lordship. Subsequently, the respondent have appellant counsel is actually thankful for the respondent for providing these points, Your Lordship. The respondent has stated that the no objection letter was already got through the Lydia. So there itself they are accepting that it was the face of the Lydia, so the resemblance related contention can be rejected, Your Lordship. Subsequently, the second respondent has stated that we want to depict her in a confident, elegant way. There also they have accepted that it was the Lydia's face only, Your Lordship. So the resemblance related contention can be easily rejected because they itself accepted it is Lydia, Your Lordship. Moving with my fourth contention, the first respondent has stated that animals are regarded as a legal person. So the artificial intelligence can be regarded as a legal person and can be provided with the copyright. But in the Naruto versus Slater case, where it is called as a monkey selfie case, Your Lordship. In that monkey selfie case, the monkey have taken a photo of its own self. So that particular photo was taken by a particular person to the copyright work in the name of the authorship. They have asked the authorship in the name of the monkey, Your Lordship, because it has the legal person. But the court declared that only for the natural person, the particular copyright protection can be given, and only the natural person can be regarded as an author, Your Lordship. So the legal person related contention given by the appellant can be rejected, Your Lordship. Subsequently, the first respondent have stated that the first ownership can be granted to the company, and the second or co-authorship can be granted to the artificial intelligence. That is what the respondent have stated. But the respondent have nowhere proved how AI can be regarded as a person, Your Lordship. They have only contended our points, but they nowhere provide any substantiation in relation to the issue 1, Your Lordship. Subsequently, they have asked that why can't the company can be the author, Your Lordship. But our humble contention is that, Your Lordship, the person who causes the work to be created. As in the fact itself, they have stated that all the data were fed from the various copyrighted works. The respondent MS Creative AI Limited nowhere given their own original data. In the absence of not providing any data, how come the respondent can be regarded as an author, Your Lordship? They cannot be regarded as an author, Your Lordship. The second respondent is a Lordship function. The second respondent have stated that the registered lacuna in the law, but the council is highly contending that, Your Lordship. On the 9th February 2024, which is the last month, Your Lordship, the Government of India, Ministry of Commerce and Industry have stated that, therefore, there is no requirement to create a separate category of rights for the AI and its related inventions. And they have also stated that the current legal framework under the Patent and Copyright Act is well equipped to protect the artificial intelligence generated work, Your Lordship. So, it is impliedly stated that no separate category of rights can be provided to the artificial intelligence, which means, as per the Salmon theory, anything being capable of holding rights and liabilities only can be regarded as a legal person. So, they impliedly stated it cannot be regarded as a person. In the absence of personhood, it cannot be regarded as an author also, Your Lordship. In addition to that, one of the essential point has to be noted in relation to the fair use dealing, Your Lordship. The second respondent has stated that it is for the research purpose and for the personal use. If it is for the research and for the personal use, why it was exhibited in the art gallery, Your Lordship? It is especially for the commercial purpose, Your Lordship. Whenever a particular artwork is used for the commercial purpose, it does not fall under the ambit of the section 52 of the Copyright Act, Your Lordship. Additionally, this is one of the main contention, Your Lordship. They have stated that it was involuntarily created the Lydia in the shape in the swimsuit kind of dress, Your Lordship. But similarly, if an art was created by the Raga in relation to the caste, creed and religion, at the time also the respondent will negligently act, but it amounts to a national importance related problems, Your Lordship. In addition to this, they have stated that the knife, as like a knife, it is like a tool, Your Lordship. So if it is regarded as a tool, whether the pen can be granted copyright protection and whether the pen can be regarded as an author, Your Lordship. That is also our humble contention, Your Lordship. Only final contention, Your Lordship, with your permission, Your Lordship. Your Lordship, the respondent has stated everything in relation to the issue 3, Lordship. But the respondent has stated that the purpose of the purpose in relation to the posting in the social media, Lordship. But the issue 3 is about whether training AI with the copyrighted work. Training AI with the copyrighted work is whether regarded as a fair work or not, only the issue 3. But they are completely deviated from the issue 3 and they are just contending a general arguments, Your Lordship. They nowhere substantiated any point to prove the issue 1 to 4, Your Lordship. That is our humble contention, Your Lordship. That concludes my submission, Your Lordship. It's a pleasure arguing before this bench.
Council seeks permission to sided with the arguments of the council. Much obliged. My lords, in the initial submissions made by the council, the honorable bench was certainly in a position to ask the learned council on what the definition of person is. And upon the reference to General Clauses Act, they did say that the term person includes natural person and artificial person. But then, my lords, if I may please have your attention to General Clauses Act itself, the terms person, if I may read the act as such, it reads that person shall include any company or association or body of individuals, whether incorporated or not. It does not say anything about natural person, and they should have not certainly misrepresented legally for this honorable court on the first instance. Second instance is that, my lords, they have made a lot of assumptions. Certainly, my lords, but it does not include natural persons in this regards. My lords, if they wanted, they could have.
What is the meaning of the inclusive definition?
My lords, inclusive definition
That can be other categories also.
Certainly, my lords, but since the Act itself is general clauses add by nature, they stated that it includes natural persons too. If at all they took this honorable court through the exact provision also, it might have not been a problem. But then if they were asked to quote the exact definition, I guess they were in a place to quote it as such, but not include natural persons in regards for their convenience. And then, my lords, in the second contention to the council would like to put forward is that they made a lot of assumptions and probably added to the facts of the case. Very two significant ones are that they filed a criminal case before a magistrate. My lords, the council will be more than happy if they are able to take us through which part of preparation states as such. The second fact they made up was that, my lords, 12 million images were fed, getting images were certainly fed inside the AA. Even that is not present anywhere, my lords. The proposition is lacking on what was fed or what was the source of data which was given to, which might include social media aspect too. Thereby, my lords, the third instance is that, my lords, the learned counsel were quoting the judgment of University London Press. My lords, the judgment is very old in nature, and then it was certainly overruled in the case of Rupendra Kashyap, whereby, my lords, University of London Press was certainly dealing only with doctrine of sweat of the brow. It did not deal with doctrine of modicum of creativity, which we are following thereby. My lords, it is to be noted that Eastern Book Company judgment, it remarked by the Honorable Supreme Court, it remarked that modicum of creativity is so overrated that we will not be able to execute it. University London Press for doctrine of sweat of the brow is so underrated we will not be able to determine. Thereby, the Supreme Court in EBC judgment created its new test called midway test, whereby it combined all the 5 elements together, my lords, getting skill, labor, judgment, creative and intellectual. Thereby, my lords, to be quoting University London Press judgment is not possible before this honorable court, and it cannot be certainly accounted into the review, my lords. My lords, and then certainly, my lords, again and again, if they have approached this court under commercial jurisdiction, why do they have to again make a lot of submissions about obscenity again and again? It's something the council would like to question, my lords. My lords, even going ahead, my lords, when they said it is the modest, no women would be ready to get costs or modesty and come forward. My lords, they have interpreted their own term of malleate and decided it's a swimsuit. As my counsel already pointed out, malleate is not just a swimsuit. It can be a lot of other, even ballet dancers, my lord. It has a full frock. Certainly, my lord, it could even be considered as a malleate. And just because they can regard it, for their case, they cannot interpret malleate as that regards, my lord. My lords, even if you take the proposition, it says an elegant malleate. My lords, if it was a swimsuit, no proposition drafter would have been with an intention to put elegant before the word malleate. And that regards, my lords, not just that word, the same proposition, the same line uses many words like poise, elegant, and clear. And if at all, my lords, if that particular pointing was at regards, it would have been very clear. And my lords, the council, I assume the learned opposite counsel was not paying attention to my arguments. I specified that getting an NOC could have been possible if the generator of the image was able to find out that if it was so famous, any person who had generated the company would have known, oh my god, this looks like Lydia, we should get a permission from her. It would have not been a problem for us to get. But the clear fact that it did not even resemble like her, it did not even put us in a place to go or give us a premise that we should get NOC from her. But then they contemplated the fact, or they contemplated my argument itself that we didn't receive NOC in that regards. My lords, going ahead, my lords, would be co-ownership, it's not authorship. My lords, the learned counsel had again misunderstood my argument. The council was certainly iterating about co-ownership, not co-authorship. My lords, we asked for co-ownership for the company and the AA board indeed. However, my lords, it was argued that even if AA is not regarded under the purview, the honorable bench may be empowered to give copyright to the company indeed. Therefore, my lords, anything at the end of the day, give it to the company or to the AA board, we would be more than happy to get that regards, my lords. My lords, getting to the very last contention which the council would like to submit, my lords, again and again they termed it's an AI tool and tool cannot be given. My lords, the proposition makes it clear it's an AI humanoid, not AI tool. Therefore, my lords, we'll have to account in for its individual test. My lords, the very last submission which the council would like to make, my lords, is the Turing test. My lords, Turing test is something which is developed by Alan Turing by himself, whereby, my lords, there will be a screen put forward between two individuals. The AI bot is placed towards one side. This side is an actual human. My lord, they are asked to communicate with each other. If the human is not able to figure out if it's a robot or a AI testing, that's when it passes the Turing test. Thereby, my lords, Raha is a perfect. Thereby, my lords, Raha is capable of having its own judgment in that regards, my lords. Thereby, we should not be ignoring its perspectives in that regards. Is what the council would like to submit at the end, my lords. Much obliged, my lords.